Chicago probate lawyer. The passing of a loved one is never easy, and the last thing you want is added stress over how their estate is handled. Probate offers a clear and respectful way to protect their legacy while carrying out their final wishes in line with Illinois law. When everyone is in agreement, the process becomes more straightforward, but it still requires careful attention. Our seasoned Chicago probate lawyer at Illinois Estate Law can guide the executor or administrator and protect your rights as a beneficiary, taking the administrative burden off your shoulders. Probate's purpose is to transfer assets and safeguard a person's legacy efficiently. Whether someone left a detailed will or passed away without one, the goal during probate is the same: to distribute property, pay debts and taxes, and respect the decedent's wishes. In Cook County, a simplified path can help validate a will, address debts and distribute property quickly when there are no disputes among heirs, beneficiaries or creditors. The most important action an executor can take is securing formal waivers from all heirs and beneficiaries. These waivers, known as notice and consent to independent administration, show that the family acknowledges receiving notice and has no objection to the will or the person managing the estate. Obtaining them sends an immediate signal to the court that there is unity, laying a strong foundation for a faster, less expensive settlement. Some probate cases qualify for independent administration, allowing an executor or administrator to manage the estate without constant court approval. The representative must file the original will with the clerk of the circuit court, submit a petition for letters of office and present waivers and consents from heirs and beneficiaries. Once approved, the court issues letters of office, which grant authority to collect and safeguard assets, pay legitimate debts and taxes and distribute property to beneficiaries. From that point forward, the representative is expected to act in line with Illinois law, honoring the decedent's wishes and fiduciary duties. Probate involves notifying all interested parties, addressing creditor claims, resolving tax issues and making sure distributions follow the law. Executors must manage these responsibilities diligently, while beneficiaries need assurance that their rights are respected. Creditors also have defined rights to payment under Illinois law. A Chicago probate attorney can provide representation at every stage, preparing petitions, advising representatives, reviewing estate planning documents, and addressing claims efficiently. Illinois provides streamlined alternatives to full probate in certain situations. A small estate affidavit allows families to collect and distribute personal property without opening a full probate case when the decedent's personal property does not exceed the statutory limit. The affidavit lists all assets, debts, heirs or beneficiaries, and the distribution plan. It must be notarized and accompanied by a death certificate and, if applicable, a copy of the will. The affiant promises to pay debts and liabilities before distributing assets. Real estate generally cannot be transferred this way. A summary administration is permitted when the estate's gross value is low and there are no unpaid or unknown claims, and all heirs and beneficiaries must consent in writing. This process is governed by Section 9(8) of the Illinois Probate Act. For real estate, a transfer on death instrument allows the property to pass directly to named beneficiaries without probate if properly executed, witnessed, notarized and recorded during the owner's lifetime. It remains revocable until death. The Cook County probate system follows specific steps. After death, a petition to admit the will and request letters of office is typically filed within 30 days. Once the court approves the petition, it issues letters testamentary or letters of administration, authorizing the representative to manage the estate. Within 14 days after the court's order, notice must be sent to heirs and legatees informing them that the will has been admitted and a representative appointed. Creditors must be notified by publication once a week for 3 consecutive weeks, and they have 6 months from the first publication to file claims. A final accounting occurs after the 6-month creditor period ends. The representative prepares a detailed account of all transactions, including an inventory, income, disbursements, and remaining assets. Once all debts and taxes are paid and distributions made, the representative files a verified final report and requests discharge. The court then closes the estate and releases the representative from duties. Probate need not become a drawn-out ordeal. With careful planning, clear communication, and proper filings, a probate in Cook County can move forward with dignity and speed. Working with a local Chicago law firm that knows the county's procedures can make a real difference for both beneficiaries and executors. Illinois estate law notes that having a Chicago probate lawyer can guide you through each responsibility, from preparing petitions and obtaining waivers to managing notices and final accounting. The law firm emphasizes transparent flat-fee pricing, secure communication, unlimited attorney consultation, and modern conveniences like virtual meetings and e-signing. For beneficiaries, this means confidence that rights are respected. For executors, it means support with petitions, notices, and inventories. Illinois Estate Law is a law firm with a client-first approach, committed to honoring loved ones' wishes while keeping the process efficient and grounded in the law. Contact Illinois Estate Law at 312-373-0731. Their office is located at 4422 North Ravenswood Avenue, Suite 212, Chicago, Illinois, 60640, United States.